So either welcome back from wherever you found to have lunch. Those of you in our viewing audience, welcome back from the kitchen, presumably. So we're ready to start again with the afternoon session. And we're going to begin with Peter Cullen from Stikeman Elliott, who's a noted practitioner in the Admiralty and shipping area, who's going to be, as you see, speaking on ship source pollution regimes for Canada. And he calls it a primer. I'm not so sure it is. We'll see.
Thank you very much. Good afternoon, ladies and gentlemen. It's a pleasure to be back in Halifax, and certainly a pleasure to be at Dalhousie. As was mentioned, my presentation is called a primer. I'm going to talk about ship source pollution regimes from a Canadian perspective, primarily looking at conventions, international conventions, and how they apply in Canada. Canada has gone a different route from the US on some of these regimes, but I'll explain a little bit as we get into more detail about why that has happened. By way of the backdrop, let me just remind you that navigation and shipping under the Constitution Act falls under federal jurisdiction. It's the federal government that has the authority and the jurisdiction to deal with issues involving pollution from ships, and we're talking ships, not boats. And under its federal jurisdiction, it has that jurisdiction in the internal navigable waters. When you think, for instance, of the St. Lawrence Seaway, the river, the Gulf, those sort of waters, the Saguenay River. I'm coming at it, of course, from a Quebec perspective when I describe those rivers, but all the navigable rivers in Canada. Some years ago, I had a case involving a dinner cruise ferry type ship on the Red River in Manitoba that ran over some fishermen in canoes. The fishermen brought an action against the ship and put forward certain principles of provincial law in Manitoba. I had to remind them that it was a navigable river. It was federal jurisdiction. Indeed, the river, the Red River in Manitoba, has Canadian hydrographic charts. There are aids to navigation. It's federal jurisdiction. So in terms of sources of Canadian shipping law, when we look at what that law comprises, there's a term we call Canadian maritime law. It is a term defined by case law over the last 20 years, and essentially it has embraced the principles of common law from the UK, as enhanced by Canadian case law and Canadian statute law. And if you go back and look at some of the authors who've talked about Canadian maritime law, I'm thinking in particular Professor Tetley, who passed away a few years ago but taught at McGill University. He goes back even farther and says some of those common law principles derive from civil law principles, but that's not the purpose of a primer. I'm just going to talk about Canadian maritime law. And it's largely founded on common law principles coming out of the UK and English law, as supplemented by Canadian case law and by Canadian statutes. And for the purposes of this discussion, as we go through the analysis, you'll see that a number of these conventions that I'm going to be talking about arise through the International Maritime Organization. It's a body located in England. It's a UN agency, started in 1958, and it is the primary UN agency that looks at safety and security of shipping and the prevention of marine pollution by ships. The IMO has set forth quite a number of international conventions for shipping. We'll talk about a few of them in the course of this paper. But in doing so, in adopting those conventions, it consults with member states. Canada is an important member state at the IMO table. It also consults with other organizations in the world, trade associations and other players. And I've mentioned the CMI here, the Comité Maritime International. It was started in 1897, populated primarily at the beginning by ship owners and ship insurers. And it was the precursor, in a way, of the IMO in putting forward international conventions before the IMO existed. The Load Line Convention is one, collision regulations, and others. But the IMO has taken over that position since 1958. As shipping got more sophisticated, the UN wanted to step in and deal with some of these international issues. But the IMO still consults with the CMI, and the CMI, to its credit, also acts as an umbrella organization for a number of maritime law associations throughout the world. One of them is the Canadian Maritime Law Association. Will, sitting at the end of the table with the bow tie, is the past president of that association. And Peter is on the executive of that association, as I was for many years. The Canadian Maritime Law Association, just to take an example, gets consulted by the CMI, puts forward responses to the CMI that get fed up to the IMO. So we have a kind of a bottom-up situation where the IMO is consulting with member states and with other organizations. I've mentioned Green Marine in my PowerPoint presentation and Highway H2O. They are referred to in my paper, but Green Marine is an association of shipping interests, ports, ship owners in the US and in Canada. Their website is quite informative. You can go and look at all the efforts they're making to contribute to pollution mitigation risks. And Highway H2O, I've mentioned the website for that in my paper. It's a term put forward by the US St. Lawrence Seaway and the Canadian St. Lawrence Seaway groups to, I think, dramatize why it is that shipping goods by sea is more energy efficient and more pollution efficient than doing it by railway or by truck. So these are some of the examples of how these players consult with the IMO and try to put forward uniformity in terms of enforcement and standards. The last thing I want to talk about was port state control. Again, this is through the IMO, but port state control essentially is a term used for the sharing of information in various ports throughout the world when ships come into those particular ports. Everyone is trying to enhance the standards of international shipping. There are, from time to time, rogue players within that industry, and the goal of port state control is to go aboard ships, do random inspections, and keep a data record of infringements of domestic policy, domestic legislation, and keep a track record of these ships as they go from one port to the next to make sure that they are continuously inspected and brought up to speed. So under the IMO process, through its different committees, and I've mentioned three here, the Maritime Safety Committee, the Maritime Environment Protection Committee, and the Legal Committee, after this consultation process, they will draft convention language. It goes before the IMO Council and Assembly, and in due course, depending on the type of convention they're dealing with, it'll get ratified by the Assembly, and then it goes to the member states. And as I said before, Canada is one of those member states. And through a series of ratification acceptance steps, which follow the Vienna Law on Conventions and treaties, these conventions then get promulgated and ratified. And Canada will largely adopt these conventions and then implement its domestic legislation to correspond with the convention. So I'm going to be talking about oil pollution, what we call H&S, hazardous and noxious substances, ballast water, and recycling and wreck removal. Now, the first three, Canada has adopted some of the oil pollution conventions, and it has adopted the H&S convention, but not yet brought it into force. And ballast water has been adopted, but is not yet enforced. I'll go through that in a moment. Recycling and wreck removal, you might say that's a bit of a stretch in terms of pollution, but I thought in terms of environmental risks, we should include it because there are two conventions that IMO have brought forward in terms of scrapping ships, how ships should be safely scrapped, and some of the wreck removal issues as well. So for oil pollution, we're looking essentially at two statutes in Canada, the Canada Shipping Act and the Marine Liability Act. I'll come to the Marine Liability Act in a moment, but under the Canada Shipping Act, we have a framework for pollution prevention, response measures, and enforcement. And the goal is that the polluter pays. And it sets forth a framework whereby ships get inspected, their logbooks get inspected, their oily water separator books get inspected, their computer programs get inspected, essentially trying to maintain a program that everyone will adhere to mitigate these pollution risks. And in doing that, under the Canada Shipping Act, Canada has implemented the International Convention for the Prevention of Pollution from Ships, what we call MARPOL 1973-78, and the OPRC Convention. This is the Convention on Oil Pollution Preparedness, Response, and Cooperation, 1990. Again, the ship owner, the ship is responsible for pollution prevention and cleanup. And part of that process in enforcement and maintaining standards is that the ship/ship owner must have an arrangement in place with a recognized response organization that will assist in cleanup of pollution incidents. And it must have a declaration from its insurers that it has sufficient insurance to cover those costs. So, some years ago, I was involved in a spill in the St. Lawrence River. It was a Canadian ship, a bulker. It was in some bad weather. It was alongside a dock, and it ranged against the dock. It reached one of its bunker fuel tanks. We had a large spill in the St. Lawrence River, and within 24 hours, the response organization was on site. The ship owner, frankly, had a limited crew. It could only do certain things. It didn't have the equipment. That's not unusual. That's why you have the response organization. The response organization was based in Quebec City. Within 24 hours, it was on site. It brought its pollution cleanup equipment, a lot of boats to monitor the spill and get the cleanup gear out there. This lasted a month, this cleanup process. The ship owner wouldn't have had the staff or equipment to deal with that, but having the response organization in place meant that the mitigation efforts could begin very, very quickly. And as an example of how that works, the response organization rented a hall, part of the city hall facilities in this particular village in Quebec, set up a table like this, had all its computer equipment, began hiring people right away, began listening to the stakeholders right away. So we had Environment Canada people there, we had Environment Quebec people there, because it was a provincial park across from the harbor. Indigenous people, Aboriginal people were there because they had certain rights that they had asserted against this provincial parkland. We had fisheries officers there as well, so we were dealing with a number of stakeholders, and the response organization dealt with that, dealt with the cleanup, dealt with the closure of a shellfish area, temporary closure of that because of the oil. There were migratory birds. I'll come back to that in a moment. There were issues involving that and cleanup of these migratory birds. And at the end of the day, we succeeded in cleaning up the oil, obviously at great cost. And we applied those provisions that we see here under these international conventions to do that. I'm sorry I missed part of the presentations this morning, but under the Canada Shipping Act, we have pollution prevention officers. They do a number of things similar to what we heard earlier today. They'll go aboard ships where they have reasonable grounds to believe that there might have been an incident or some faulty equipment. They can speak with the crew. They can go into the computer systems on the ship. They can inspect documents. And in certain instances, they can remove evidence from the ship. But the idea is that there is a force or a group that is proactive and gets into the ship and understands the systems and tries to pin down if there's been a pollution incident or the likelihood of a pollution incident. And under that Canada Shipping Act, the Minister of Transport has certain powers to step in if there's a cleanup that's going wrong. The Minister can step in and do the cleanup or oversee the cleanup and recoup those costs from the guilty party. I mentioned there was a second act, that is the Marine Liability Act. And the Marine Liability Act, under Part 6, implements a number of these IMO conventions that deal with compensation and civil liability. So for civil liability, under these provisions, I'll take, for example, a tanker. When a tanker has a massive spill, the tanker owner can apply to the court and seek to limit its liability. Depending on the size of the ship, the size of the spill, there's a certain fund that's created. and it can make its evidence that it's entitled to limit its liability and tender the amount of that limitation fund. And if the claims exceed that fund, then there is another fund in excess of that called the International the International Oil Pollution Compensation Fund, the IOPC fund, which will act then as a fund of second recourse. There's also the ShipSource Oil Pollution Fund, the SOPF, which is a Canadian fund which can be accessed under certain conditions. And I've referred to orphan claims, and those are claims where you find the pollution, but you don't know which ship did it. And when you have orphan claims, you can access those funds as well. So the ship owner can limit his liability if the spill has not resulted from an act of war. When we have a collision between two ships, they're jointly and severally responsible. There are some other provisions as well that deal with the right to limit. Now, there is an interplay. We see it from time to time. Certainly when I had that case in Quebec, as I mentioned, we had these environmental officers, Canadian, federal ones, provincial ones, and we do see situations where we have an interplay of federal and provincial statutes, where an example being the Migratory Birds Convention Act, where we have oil that gets into non-navigable waters, and we sometimes see in those cases where ship owners and crews are being sanctioned under these different statutes depending on where the oil has ended up. And that can give rise to some complications in terms of defending those officers, those people, or those entities. And in the case that I had in Quebec, in the end, it was just federal jurisdiction. The second convention I wanted to talk to you about is the HNS Convention. And this convention was put forward in 2010. It's anticipated that Canada will ratify it in 2018. It doesn't apply to oil spills. It applies to those substances not covered by the Civil Liability Convention. And if you look at the IMO website, you'll see that there is a tremendous amount of these sort of substances. I've mentioned some of them here: liquefied gases, harmful products carried in containers, chemical hazards, and the like. Apparently there's 2,000 different types of these substances transported by sea, 200 million tons of chemicals traded annually. So this is the other side. We've got the oil problems. What about these other toxic chemicals? And they're being carried great distances by ships as well. And so the HNS Convention came out in 2010. Transport Canada has recently circulated some reporting requirements. They're open for comment or being looked at by industry. But part of the initial reporting requirements can be found in Part 6 of the Marine Liability Act. Again, this is a convention that provides a prevention, preparedness, and response regime like we see for under the Canada Shipping Act, and a framework for liability and compensation as we see under the Marine Liability Act. And here, the fund will be financed through contributions from the receivers of these chemical substances. And I should have mentioned that for the oil pollution, those funds are funded by the receivers of the petroleum products. The next convention I wanted to look at is the Ballast Water, what we call the Ballast Water Convention. It came out in 2004. Canada ratified it in 2010. It has yet to be implemented in Canada, but it's anticipated this will happen next year in 2017. It's caused a number of problems as Canada tries to develop its domestic legislation to correspond with the convention. And I say that because there are some issues on the technological level. Ballast water is water that gets picked up and put on a ship to keep the ship at a certain depth in the water. It's for stability purposes. So if a ship is carrying light cargo or is not carrying a full cargo. Sometimes you'll ballast the ship to keep it low in the water. And then when you get to the next port and you want to load more cargo, you have to remove the ballast water. And we have seen over the years some invasive species have come into Canadian waters because ballast water from other jurisdictions that contain these species, which were not invasive in those lands, become invasive within Canada. I'm thinking in particular zebra mussels in the Great Lakes. So IMO developed this convention to try and deal with or maintain certain norms so that ballast water could be treated or exchanged outside Canada to avoid these invasive species. And indeed, under the current ballast water control management regulations that we have in Canada, ships that come into Canada, into Canadian waters with foreign ballast water need to exchange that water outside Canadian waters and then take in the waters closer to Canada when they do the exchange. And then certain things need to happen when the ships come into Canadian waters. And essentially under this convention, they are trying to standardize the treatment systems on ships to kill or essentially control these invasive species so that you can treat the water before it's discharged in Canada. It has raised some issues in Canada because our internal waters are largely fresh water, and a lot of the technology deals with salt water. We have particularly cold waters in Canada, and most jurisdictions in the world do not have those issues that we have with cold water. I'm thinking of the Arctic, I'm thinking of the Great Lakes. And there's a discussion going on in industry as to whether there's a sufficient level of technology that can apply across the board. And Canada is looking at that very carefully because there's not much sense in implementing a convention that requires certain standards to be met when the technology is not there to actually meet those standards. It's also created issues in the Great Lakes because there are a number of states in the Great Lakes, American states, that are not following the convention and have their own standards. A number of ports in those American states have different standards. So operators in the Great Lakes are confronted with a series of challenges, technology and jurisdiction, and they are trying to see if those organizations can develop a constant or uniform type of standard to deal with that. So Canada still wants to implement the convention in 2017, but this is creating timing issues and implementation issues. And amongst the implementation issues that have been advanced, and Canada has yet to react to them, is will there be a carve-out for the Great Lakes? Will there be a carve-out for certain areas west of the Port of Montreal or maybe west of the Port of Quebec City? These are issues that are being advanced so that we can get a better understanding of how it's going to come into force. Because if it comes into force and the standards can't be met, then the ships will have to stop. The last two conventions I wanted to speak about are the recycling and removal conventions out of the IMO. So we have this convention, the Hong Kong Convention, came out in 2009, dealing with the safe and environmentally sound recycling of ships. You can imagine tankers at the end of their useful life. How are they going to be dealt with? How are they going to be scrapped? Oil rigs, how will they be dealt with and scrapped? FPSOs, these floating production and storage, offshore units, how will they be dealt with? And we have seen, and maybe you've seen it too, these scrap yards, I'll call them scrap yards, but they're beaches in India where at extremely high tide, mega ships are brought in, Navy ships or ex-Navy, ex-British Navy ships, these oil rigs, what have you, are brought in. And then on the low tide for the next 2 months, people work on those ships and essentially break them down by hand on those beaches. And you have all the asbestos, heavy metals, chemicals, toxins, what have you, either leaching into the soil or going out on the other tides, and it's certainly not environmentally friendly for the people who work on it. So the IMO, feeling again that it has this responsibility to maintain safe and secure shipping, has advanced this convention to say this is how these ships should be recycled, scrapped, cut up, broken up. And so it has put forth a series of guidelines to inspect and survey ships during their lifetime so that there's a record of the chemicals and toxins that are on board the ship. And we've seen in the past few years, certainly when I've sold a number of ships to breakers, to the yards that break them up, we would always produce, the ship owner would produce what they call a green passport. And the green passport wouldn't be a document that would document all the asbestos, usually by weight and where it's placed on the ship. Lead paint, toxins, chemicals, things of that nature. The book could be thick, inches thick, but you hand that to the scrapyard who's buying the ship for scrap, and they need to comply then and remove these things in a safe manner. Thank you. So that has yet to be adopted in Canada. We don't have many breakers in Canada, but we have ships that are reaching the end of their useful life, and ship owners are responsible, and they want these ships to be scrapped, in accordance with good practice. And so at the moment, those ship owners are insisting that the scrapyards show that they are abiding by the guidelines, notwithstanding that the convention is yet to come into force in Canada, and certified that ships are being broken up in a certain manner. And often Canadian ship owners will sell to, the ones I've been dealing with, sell to shipyards in the Black Sea and Turkey and Greece to avoid this problem that we've been seeing in India. And lastly, and again, as I said at the beginning, you might think this is a bit of a stretch, but from a pollution point of view, but there is a convention that came out in 2007, not yet adopted in Canada, dealing with the removal of wrecks. And you may have seen from time to time ships that have gone aground on the Great Barrier Reef in Australia, ships that have gone aground on some reefs in the Caribbean, in Asian waters. In the old days, a ship went aground or sank, it was left there. Of course, ships in the old days were wooden. They didn't carry a lot of these chemicals and pollutants. There's thousands of them around the world. But if you have these oil rigs, if you have these large FPSOs, if you have tankers, if you have container ships containing all sorts of chemicals, you don't want them on the Great Barrier Reef. They shouldn't be there in the first place, and they shouldn't stay there. So IMO has come forward with this convention, and the goal is to minimize adverse impact to coastal environments. So it establishes wreck reporting requirements, criteria to determine hazards to the environment, measures to facilitate removal not just of the ship, but of the cargo as well, and liability and insurance requirements. So we don't have a lot of reefs in Canada that I'm aware of. I'm sure there are some, but this is a convention that will eventually get adopted by Canada. We need to see how it develops first, but I think from a pollution point of view, it's an important one and one that we need to understand. I've written my conclusions here, and you can read them, but I wanted to respond to a question that came out this morning when I came in about are these fines and penalties a cost of business? Are they treated that way as a cost of business? And I can tell you, and I think some of the other lawyers in the room who act for Canadian shipping interests will agree that the fines that we see, and they are increasing over time, especially if there's repeat offenders by Canadian ship owners, are treated very, very seriously. Often those fines are reported straight to the board. Often they're have to be reported to the insurers. The Crown prosecutors keep a track of which owners, Canadian owners, have been fined, which ships have been fined, the types of situations that have led to those fines. And the penalties are certainly in excess of what would ordinarily be the cost of business. And perhaps one of the biggest hammers is the detention rights that pollution prevention officers have and environmental protection officers have to detain ships when there's a reasonable risk, either that they are offside on their paperwork and on their reporting, or offside in terms of a pollution risk. So it's treated seriously. That hasn't always been the case, but I think in the last 15 years, there's been a serious effort by the Crown to move forward and get the cases before the courts, use the detention orders, and detain ships, all kinds of ships, tugboats, container ships, tankers, to make sure that environmental safety is first and foremost in their minds. And it does reach into the boardroom, and we've seen some statutes that actually allow for charges to be brought against board members if they don't have or have not adhered to a proper oil spill response plan. Thank you.
Wait here. Thank you very much, Peter. I will open it up for questions from the web and also those present. And I'll start it. Okay, if there's nobody ready to go, I will start. Although not yet as far advanced, the Hong Kong Convention, there's been a fair bit of tension in the early stages of the development of that convention with the Basel Convention regime for transportation or transboundary movement of hazardous waste. I know they had some efforts to consult back and forth and try to resolve and support each other. Does that have an impact in Canada at present, or we simply go with Basel for the moment and wait for the coordination with the Hong Kong Convention to come?
Well, it's a very good question, because under the Basel Convention, there is some issue as to whether it applies to a ship. The Basel Convention applies to certain commodities that get exported from Canada. There's been some argument that it doesn't apply to a ship that's being exported from Canada. I don't think that's been ruled on by the court yet, but nobody particularly wants a ruling, and I think that's part of the reason why we have that convention, is to show people are in good faith and trying to adhere. And certainly we saw the development of the Green Passport in response to that a ship owner could say, I have given notice of what is there. But the Basel Convention deals with the export of goods, and often these sales are structured so that it's the scrapyard who buys the ship and exports it. So there's some tension between the two. But I do think the Hong Kong Convention comes back to that.
Anybody yet? I have one. Okay, you go ahead. I'll follow.
I don't know much about shipping at all, but I was sort of interested when you started talking about the zebra mussels, because I have had some relations with the International Joint Commission and the Boundary Waters Treaty, and that has been a concern I know that has been raised there. And it struck me that a lot of Canadian shipping is actually in the Great Lakes. It's fresh water. And I wonder if you could talk about how that plays out in the context of, well, for example, there's a pollution provision in the Boundary Waters Treaty. The International Joint Commission has both reference powers and some quasi-judicial powers. How does that play out in the Great Lakes in terms of the interaction with this sort of regime you've described and the boundary waters regime we have with the United States?
Well, let me first of all say that a lot of those domestic shipping interests will argue that they never take on foreign ballast water. A lot of those Canadian domestic ships don't go beyond, I'll say Newfoundland,
Right.
Nova Scotia. Some of them may have qualifications that allow them to come down the eastern seaboard of the U.S., like a Caribbean class, and some can go deep sea. But just limiting it to those, what I'll call domestic trade ships, they are being confronted now with this ballast water issue, notwithstanding the fact that their argument is they're not bringing in foreign ballast waters. Now, in terms of the interplay between the two jurisdictions you're talking about, that has yet to fully unfold. What we need to understand, first of all, is what are the domestic U.S. states doing? And you'll know from your work with the International Joint Commission that those states have very, very powerful lobbies. I've been involved in instances where, as you know, in your commission, you regulate the level of water that flows through certain parts of the St. Lawrence River, and you have people on the southern part of Lake Erie who want higher levels of water, and then there are ship owners who are trying to move goods through the St. Lawrence Seaway who need a different level of water because you're starving the areas down below to keep the water up above. So we see that tension from time to time. Certainly there's tension on the invasive species, and those states who have come out with their own requirements are basically saying we want zero tolerance, and we don't care about international regimes. We have no interest in what anyone else is doing. We just want to have what we have. And I mentioned at the beginning of my presentation that the U.S. often does things differently. They did not sign on to those pollution conventions that I've talked about. They have their own OPA, Oil Pollution Act of 1990, that came forth after the Exxon Valdez incident up in Alaska. And that has been part of the tension and challenge in the international community, is trying to not fight with the U.S., but trying to develop a system that can respond to those needs and at the same time allow the state members to adhere to their international requirements, because we can't have 6 or 7 different standards in the Great Lakes, plus Canada. And so I'd like to hear your answer to that question.
I'll pass on that.
Yeah.
But I think it is an interesting one because, for example, when lake levels are low, one of the first things you hear about is the Chicago diversion, which is incredibly important for keeping shipping in the Mississippi system afloat, if you will. And there have been attempts over the years to increase the size of that diversion, which is regulated by the U.S. Supreme Court, of course. Right. And it often has been a real fight between the Great Lakes states and the states beyond the lakes in terms of keeping that water.
If I may interrupt you just for a second.
Sure.
That phenomenon has another side effect, which is the invasive species that come up through that system. And we're talking about essentially a type of carp that is not native to North America, that has been introduced by sports fishermen. And it's come in and it's decimated local species, and nobody wants that in the Great Lakes. So that's another part of the challenge.
I have one. Yeah, I got one quick one, and it's just this I'm totally ignorant on, but you talked about this problem of shipwrecks. Is there a phenomenon of what you might call orphan shipwrecks? Because there is a phenomenon that exists in Alberta of orphan wells, where it was abandoned years ago, and they had to come up with a solution. They ended up taxing the industry, putting a levy on the industry, and that's possible because you had a regulatory board that could do that, and that's basically the solution. And I wonder if there's an equivalent problem with some of these shipwrecks that have been around for a while.
I don't believe so. Now, ordinarily, if a shipwreck is a hazard to navigation, there's an obligation to remove it. And if you can no longer find the owner, if the owner is insolvent, then you have states that remove it. You might remember the Irving Whale, the barge that sank in 1972. It was not an orphan situation. I mean, the owner was there, and the Crown dealt with it. It got resolved as between Irving and the Crown, and there was litigation after that on other aspects. It's not a pure orphan one, but it's one that was not a hazard to navigation, but the fear was that the PCBs and the oil in the tanker, in the barge, would leak over time or break up and destroy the lobster fishery off PEI.
We have one from the web, and I'll read it. Not sure if this question is coming a bit late, but was wondering if Peter could comment on whether he's seeing customers of shipping companies starting to seek greater contractual commitments regarding environmental standards, or seeking better reporting or audit rights with respect to environmental performance. My interest stems from increased focus on supply chain management for many organizations. Interested if this has created tangible changes in the shipping industry.
Well, it's a terrific question, and the short answer is we've seen a lot of it. I'll take the tanker industry as an example. You take Shell or Imperial Oil, any one of the oil majors will only charter ships that are of a certain age, that have been vetted, that have met, tick the box of every major requirement, and they have essentially a zero toleration for anything that's offside. And if you are going to charter your ship to one of those oil majors, you will be put off hire if you don't meet those criteria. So that's something that's been in place for quite some time. I think the problems that we see from time to time involving those tankers that make the news, I'm thinking of the Prestige and the Erica and others, they're not the ones being chartered to the majors. So the answer to the question is yes, in terms of the oil majors. We do see from time to time, well, container ships, all the major, I'll say consumers, those stores that sell goods that often arrive in container ships will have this similar sorts of standards where they need to have certain types of ships. Nobody wants to be associated with what I'll call a rogue operator. The consequences are just too high. Reputational risk, of course, is huge. Financial risk is huge.
Actually, just one last comment, that it's interesting to hear that because it arises in the living resource context as well. It's involved in a case some years ago where a owner of a refrigerated vessel had chartered it to someone who then subchartered it essentially to themselves via another arrangement and took it off to engage in illegal transshipment of fish in a fishing zone and get caught. And they had a provision in the contract that prohibited them from using it for illegal purposes as a starting point. And the question was how far you can take the definition of illegal purposes.
Right.
Yeah. Okay, I think we're ready to go to the next speaker. Oh, sorry, I have to keep remembering. I gotta step in. Thank you very much again, Peter. We appreciate it. I'm going to get the next PowerPoint up, and our speaker will be Peter Pamel, who's a partner with Borden Ladner Gervais in Montreal, and is going to be speaking on the topic of, what's your title? Okay, I'm just trying to find it here. The Arctic shipping issues and the LNG as a clean shipping alternative. And it must be, okay, we seem to have gone missing with it. I know it was here. Okay, we'll reload it. Oh, you got it. Yeah, okay, because it was loaded, but rather than try and find which directory it is migrated to, no doubt it's an invasive PowerPoint.
It's the, go down all the way to the bottom.
Not that
All the
one?
way to the
No.
bottom. No. Can you triage according
This one
to
here?
date? No, yes, no, triage according to date. And go all the way to the bottom. And it's,
This one here?
no, is it, no, those are, no, actually the highest one. So I go all the way to the top if you triage according to date. There it is, top one.
Okay, got it. Okay, thank you.
All right. All right, well, good afternoon, everyone. Thank you, Philip. Thank you very much for inviting me. Thank you to the organizers for allowing me to speak this afternoon. For those of you who I have not yet had the pleasure of meeting, my name is Peter Pamel. I'm a partner with the law firm of Borden Ladner Gervais. I'm in the Montreal office. Many of you may know BLG as a national firm. I happen to practice out of Montreal in the Marine Department, and I've been doing this, and someone asked me actually earlier this morning, how many years have I been doing this? I caught myself, it's getting on to 28 years. So I think it's been a great ride so far, and hopefully it'll continue. The client base that we've usually worked with are the ship owner, ship operator client base. So that's been our focus, I guess, traditionally. But I'd have to say that over the last probably 5 or 6 years, maybe closer to 7, and specifically as we've migrated our practice to more and more to Arctic shipping, we're finding that our client base has really increased, and we're doing more work with governments, more work with NGOs, more work with infrastructure development companies, mining companies, energy companies, who really are concerned with that little piece that no one really thought about when putting in a mine or putting in an infrastructure project, that little piece called marine. And how are you going to get your extraction out? How are you going to get your heavy equipment in? Well, that usually takes a ship, all right? So that's been the practice. If you look on the website, the paper that Robert Wilkins, my colleague at the office, and I prepared was on LNG-fueled ships, because we think that's the future in terms of propulsion for vessels, clean vessels going forward. But then we thought, you know what, we've got half an hour. We can talk about LNG ships, but we'd like to broaden the topic a little bit. So I'll talk a bit about LNG ships, but I'd like to really build on what Peter spoke about and really focus on the front end. all right, what type of initiatives are we actually looking at? What type of initiatives is a ship owner or ship operator looking at in terms of the future and in terms of avoiding many of the situations that we saw with, you know, with oil spills, and then getting to avoid maybe some of the fines that you see under the various statutes. So in shipping, there's good and there's bad, all right? This is good. So this is a ship going through the North Sea route, Northern Sea route on the Russian side, a wonderful ship. She's breaking the ice nicely, no issues. I think it was Professor Wallace this morning who made the point that shipping impacts oceans. Of course it does. And there's always going to be somewhat of a conflict between the operations end of shipping and the environment. However, I think the issue, though, is how we manage these sometimes conflicting interests. And I've got to tell you, from an owner's perspective, you might think, all right, owners, ships, they see regulatory compliance as being a burden, as increasing their cost of operations. I've got to tell you, to a certain extent, that is true, but to a great extent, it's not. And as a matter of fact, many ship owners who have invested in certain areas, dedicated trades, and we see this more and more in the Arctic, they're seeing higher regulation, meaning higher barriers to entry to competition. So if they're operators that have invested the time, invested the money to build the ships that are necessary to work in these very sensitive, environmentally sensitive areas, you know, they wouldn't like to see, as Peter quite rightly mentioned, these rogue players coming in that have been trading in the Caribbean or the Southeast Asia, in an area which is maybe less remote, less regulatory challenged, not challenged, but yeah, actually regulatory challenged, and then come up here and think they can operate in the Arctic with the vessels that they've been operating for years down in other areas with less compliance requirements. So there's really a double-edged. You know, regulatory compliance and the building of regulations is really a double-edged sword. So we have the good, of course, and this is what we like to see. However, we also have the bad. All right. This is a situation in Antarctica in 2007, and things didn't go that well. You do get to see, and I don't have the pointer here, but you do get to see underneath the, oh, here we go. Okay, excellent. We do get to see, here we go, underneath the Explorer, you see the gash when it struck the iceberg. There is a good news story in this, that everybody on board that passenger vessel back in 2007 was rescued. The weather was great, the weather cooperated, and more importantly, when you're talking about remote areas, there was a ship close by that was able to respond and take all the passengers off and put them back on their ship. So that in the end of the day was handled well, but you know, it's not something that ship owners, ship operators, and certainly not their underwriters want to see. You see the area here in Antarctica where the incident took place. All right, so here's what I'd like to look at. Now, as I said, the paper on the web is really limits the topic to LNG as fuel for ships, but I want to expand on that. The first thing I'd like to talk about for a little bit, and I've got 30 minutes, 30 slides. I think we're going to go through these rather quickly. The challenges and importance of shipping in the Arctic, and why are we talking about the importance of shipping? I think it was Aaron this morning who mentioned a story about someone who made a comment about aquaculture industry, saying that the best way to deal with the challenges and the problems with aquaculture is to get rid of it. Well, you know what, it's interesting because that struck a nerve because a very similar comment was made to me about 5 or 6 years ago about Arctic shipping. I was at a conference, speaking at a conference, and someone came up after the conference. We were talking about some of the challenges that ship owners have to face, and certainly some of the issues we see, the environmental challenges that we have. And I said, well, the best way to deal with it is to get rid of Arctic shipping, Arctic navigation. You know what, it caught me off guard, and I said, well, all right. I started thinking, you've got Nunavut, and in Nunavut we've got, 31 hamlets, average population between 800 people and about 1,100 people, other than Iqaluit. Iqaluit's about 7,500. But you got about 30 little hamlets, very few of which are connected by road, even fewer of which are connected by air. They have no airstrip. They're on little remote islands up in Nunavut, and how are they going to get their community resupplies? How are they going to get their food? How are they going to get any piece of equipment that goes up to those little hamlets? And the reality is, it's with shipping, and with ships going up there. So I think it's important that we look at shipping not necessarily as something we can easily get rid of, but something that we have to properly manage. Because if you don't manage the situation properly, I'm the first one to admit that things can get out of hand, especially on the environmental compliance side. I also want to talk a little bit about the changing regulatory environment that we're seeing. In particular, I think again it was Professor Wallace who mentioned air quality and some of the news were that some of the developments on the MARPOL side. Certainly ballast water convention, I'll only touch upon it with one slide. Peter did a great job at going over that. And I won't get into shipwrecks, but it's funny, the question, just your question on orphan wrecks, it's funny, we've got two situations right now that are being handled. We recently have the two Franklin vessels that have been discovered, the Terror and the Erebus first, and just recently the Terror. And there's a whole issue as to who owns them and who's got the rights to all those artifacts that are being found. The beautiful bell that came off the Erebus last year. We also have a situation, it's public knowledge, with respect to a wreck just off of the Scarborough Bluffs off of Toronto. And there was an incident involving that wreck that's clearly visible. People have been taking their little power boats and circling that wreck for years, but now something happened with the wreck, and the ownership of that wreck has become an issue again after close to 100 years. I think it sank about 1915. So there are issues that develop and crop up from time to time with these wrecks. All right, challenges. And again, my paper, my talk will be general, but I do have a slant, and you'll notice this slant on Arctic shipping only because I think from an environmental perspective, from a regulatory perspective, it's certainly the developing area. So in terms of some of the challenges, there's always a challenge of how do we get there. Do we have proper aids to navigation? Do we have the proper icebreaker assistance? Remember, navigation in the Arctic is seasonal. Anywhere in the St. Lawrence, anywhere on the East Coast, on the West Coast, it's a 12-month-a-year operation. In the Arctic, it tends to be seasonal. Now, seeing what I saw earlier today about the reduction of multi-year ice over the last 80 or 100 years, you kind of wonder how long it's going to be only seasonal, and how quickly we'll get to the point where even Arctic navigation is a 12-month-a-year operation. You've heard estimates that we're going to see the Arctic being ice-free by as early as 2030, maybe 2050. Even if that is the case, and I think we're seeing that may in fact be the case, 12-month-a-year operations are going to come a lot earlier than that because ships are getting better. We're developing, and we'll get into this a little earlier, something called the Polar class ship that are being built today. And we're going to have vessels that are able to operate in the Arctic, operate with severe ice conditions, which were not available 5, 10, 15, 20 years ago. So I think we're going to be in a situation where we're going to be seeing 12-month-a-year operations in the Arctic certainly very soon. But we still have the challenges. In particular, what happens, and this is something that certainly keeps operators up at night, keeps their insurance companies up at night, what happens if something goes wrong? Is there a port of refuge? And I've got to tell you, there are very few ports up in the Arctic. Transfer operations still take place by lightering barge and by hoses. And many of you may have seen the pictures of these tankers, Canadian tankers going up to the Arctic, going to these small communities, whether it's in Nunavut, whether it's off of Tuktoyaktuk in the Northwest Territories, and they are anchoring the tanker several hundred yards, maybe a couple of kilometers off the shore, and then running a hose from the vessel to the intake pipe on the shoreline. And that's how they supply the fuel to the communities. Now, that operation has been going on for many, many years, but it's interesting that although it's been 40, 50, 60 years that it's been done that way, we haven't seen much improvement in the technology of how discharge of fuel or delivery of fuel takes place up in the Arctic. Next thing is, of course, emergencies, and as I mentioned, the insurance companies. The Arctic is not just somewhere where you can show up with your vessel, that you can show up and either pick up a piece of cargo or deliver it. As a ship owner, you've got to deal with a number of players, and clearly we've got the federal and territorial governments that have a vast amount of regulatory compliance regimes that have to be respected. Peter touched on a few of them. But more importantly, and I think I'd have to say probably certainly more in the last 10 to 15 years, we're seeing the local communities and the Inuit groups, certainly up in the Canadian Arctic, take more and more of a front-end approach to dealing with the shipping environment in their own communities. It used to be a time, and I told a story once because I think I first became involved with an infrastructure project about 25 years ago. And there used to be a time, not too long ago, that when you spoke about the list of 20 things to do if you were a mining company, if you were an energy company looking at offshore development, and you asked the proponents of the project, okay, what are the top 20 things to do? And of those top 20 things, where do you put community involvement and community consultation? Assuming that was even on the list, it would probably be somewhere around 28 out of 30, 29 out of 30. I'd have to tell you, though, there's been a paradigm shift. And it may have been a couple of Supreme Court decisions that forced this upon the industry. It may have been a couple of injunctions that took place that cost ship owners and operators a lot of money. But in the last 5 years, community consultation and certainly the understanding of what traditional knowledge is and the use of traditional knowledge has come from being 28 on the list of 30 things to do to top 3. And I don't know too many infrastructure when I say infrastructure project developers, I mean the mining companies and the energy companies, oil and gas. I don't know too many that are, once they get over the initial feasibility, is it worth doing this? The next item is, all right, let's put our boots on the ground and start dealing with the communities and speaking with the communities and seeing how best to do it. And that, as I said, has been a complete paradigm shift in terms of how the industry as a whole is viewing community involvement. And of course, the next thing is International Maritime, the IMO that Peter spoke about, and of course, the Arctic Council. Importance of shipping, very quickly, I mentioned that you can't have community resupply without shipping. It's impossible. You can fly a few things into some of the communities that have airports, but as I said, out of the 30, there are just a handful that do. Shipping brings in infrastructure, project development, local sustainability, tourism, economic development, capacity building. I mean, the whole focus, or a big part of the focus in terms of investment in the North right now, whether you are a government, whether you are part of industry, whether you're part of the local Inuit organizations, it's all about capacity building and migrating the knowledge that is in the South, is in the universities in the South, and migrating them to the populations in the North. All right, that's all very nice, but where are we going? From a regulatory compliance issue, the first thing you saw on the agenda, and the first thing I'd like to speak about, is the Polar Code. I think many of you have heard of it, and I did, and I'm pulling a mea culpa, I pulled something off of a presentation. I was in New York with giving a presentation with Rear Admiral Poulin of the U.S. Coast Guard, and I liked the slide that he had to explain the jurisdictional limits of the Polar Code, so I swiped this picture from his presentation. I hope you won't mind. But what the Polar Code is a compulsory regulatory regime that is meant to, that's meant to regulate all aspects of vessel operations in the Arctic. It's developed by the IMO, and I won't get into who the IMO is. I think Peter quite properly and fully described what the IMO is doing. But what the Polar Code is in fact a regime that tends to focus on all aspects of operations of ships. It's really focused on two parts, or split into two parts, safety measures, and what polar class vessels, and it is introducing a new class of vessels called polar class vessels, what polar class vessels have to have in terms of operation manuals, the construction of the vessel, what the thickness of the hull, for example, is, if in fact you want to be called polar class. Manning requirements, there has to be brand new training of crew with respect to polar operations. Many of you may have seen photographs of vessels and tankers, for the most part, that are absolutely covered in ice. You look at their piping on the deck, and they are just absolutely covered in ice. And there's a thickness of ice that develops from the winds and the seas that are blown up in the Arctic. If you are on the deck of that vessel as one of the crew members, and you're out there in minus 40 and minus 50 degrees, I don't know how I could do it. I don't know how I could think. And it takes a very special person to do it, and it takes a person with very special qualifications and training to be able to operate the vessel in those conditions. So the Polar Code is introducing very specific requirements with respect to training of crew members and how to handle extreme environmental situations. It also deals with pollution prevention measures, adoption of revised prevention plans that have to be on board all vessels going into the Arctic. All right, I've got a couple of charts, and you can look at these. I'll go through them very quickly, but you can look at these. They're probably going to be on the web. The Polar Code deals, as I said, with ship safety, and you've got areas including specialized equipment, design and construction, and of course the training and operational manuals. But at the same time, they've got enhanced environmental requirements dealing with oil discharge, and for the most part, oil spill preparedness. How do you deal with your sewage on board the vessel? And we spoke this morning a little bit about garbage, or actually what we specifically was about the plastics and the microbead contamination of microorganisms. I think that topic came up this morning. But certainly the Polar Code is addressing some of those issues and trying to enhance some of the international requirements with respect to prohibition of the dumping of garbage in the Arctic. All right, we do have a Canadian regime in place right now. The Polar Code is scheduled to come into force in Canada on January of upcoming year, 2017. There is a phase-in program, because clearly it cannot apply immediately to all ships going up in the Arctic. So it'll apply immediately to new builds, and then there's a phase-in period for vessels that are already built and that are already operating in the Arctic. But we do have an existing Arctic regime, the Arctic Waters Pollution Prevention Act, but there are differences. Our present legislation is really focused on oil pollution response, preparedness, and avoidance. What the Polar Code does, it takes more of a holistic approach, and it says, all right, dealing with the risk of oil spills is one thing, but we've got to now expand on that. We're going to look at all the operations that a ship has to go through, ships and crew have to go through in the Arctic, and that's what the Polar Code is trying to introduce. So it takes some elements. I think we can see some elements of our Arctic Water Pollution Prevention Act in the Polar Code, but that takes it the Polar Code would take it to the next level. All right, in terms of application, as I said, there are comparisons. The Arctic Water Pollution Prevention Act only applies to vessels within Canadian waters, whereas the Polar Code would apply to all SOLAS certified vessels. It deals with safety, and we can go through the slides, but there is certainly a comparison to be done between the Canadian regime, the present Canadian regime, and the Polar Code. We do have in Canada right now a zero tolerance for the discharge of waste. There is an exemption, which is very, very interesting. There is no prohibition in Canada from the dumping of raw sewage in the Arctic. And there's a historical reason for that. Back when these regulations, when the Arctic Water Pollution Prevention Act was adopted, there was no technology to treat raw sewage. And the technology that existed to treat the raw sewage was found to be more detrimental to the environment than the raw sewage itself. So there's no preclusion of dumping raw sewage in the Arctic right now. However, that will change as the Polar Code does come in. There will be modifications, and I suspect now that we do have technology to treat raw sewage, I certainly see changes in that respect. Again, pollution prevention. We do have, as I mentioned, certain regimes in Canada, but they're going to be revamped and certainly developed, taken to the next level with the Polar Code. All right, that's oil pollution. What do we do about air pollution? And I think, again, the decision or the discussion was earlier this morning about black carbon and about what we're going to do with the restrictions on air pollution and what emanates from vessels in terms of burning heavy oil. Well, there has been, certainly since in the last 10, 15 years, a push to develop regulations at the IMO with respect to limiting sulfur content in fuel emissions from vessels. And we're seeing one of the annexes of MARPOL, I think Peter spoke about MARPOL, actually developing a concept that is called the emission control areas. And in 2008, emission control areas were created specifically to provide that vessels trading or passing through those areas must use lower sulfur emitting fuels in order to limit the fuel, the sulfur emissions and the nitrous oxide emissions from their fuel. So we've got, and the targets are frankly, I think achievable, and we're going to see more and more of ship owners actually moving to these targets. The idea was to have sulfur content reduced down to 0.5% as of 2020, and in the ECAs down to 0.1% as of last year, and that has been met, by the way. There are regulations in place saying that sulfur emissions from vessels in those ECAs have to be 0.1% of what they were back at the target year, and those have been met. Here's one of the problems, though. These ECAs don't apply to the Arctic, and so if you're traveling through the Arctic, you can burn heavy fuel oil. Which means you've got higher concentrates of nitrous oxide in the atmosphere, higher concentrations of sulfur oxide, and of course you've got the issue of black carbons. That's something that we touched about this morning. All right, these are the two ECAs that are presently in place. You've got the North Sea on the north coast of Europe, and of course you've got the two coasts in North America, the East Coast and West Coast. So ships passing through those areas must be burning well, they have a choice. They can burn ultra-low sulfur fuel, or they can have some other mechanism, scrubbers possibly, to provide for the final emissions meeting the sulfur and nitrogen contents as required by regulation. Which brings me to the topic that I was originally going to speak about, but I thought I'd expand a little bit. LNG-fueled ships. Now, when I speak about liquefied natural gas fuel ships, I'm not necessarily talking about LNG vessels or vessels carrying LNG. We see LNG vessels all the time. They carry liquefied natural gas, and those vessels actually do burn. For their propulsion, they will burn LNG. They take the burn off from their own cargo and use that to fuel their engines. What I'm talking about is the building of purpose-built ships that run on LNG that are not carrying LNG as cargo. These are container ships, these are dry bulk vessels, these are tankers. Now, why LNG? There are tremendous advantages to LNG, especially from an environmental perspective. We practically eliminate the response and cleanup. I was with a pollution response officer at Coast Guard a few years ago, and topic came up about how do we deal with certain, the risk of spills in the Arctic. And I said, well, how would you respond to an LNG spill? And he says, wait 30 minutes. Because in about 30 minutes or 40 minutes, the LNG that may have spilled dissipates, and it's as if it never happened. Now, I exaggerate to make a point, but to a great extent, that is one of the benefits of LNG. And so if you have a bunker spill, you're more inclined to be able to deal with it in an efficient manner than if it was heavy fuel oil. You're reducing your sulfur oxide, you're reducing your nitrous oxide, you're reducing your CO2 emissions, and there have been reports that say that over time, the use of LNG as a propulsion fuel is probably more efficient than using heavy fuel oil or diesel and then combining that with a scrubber system. But that's, that really depends upon the nature of the vessel. We do have very quickly some LNG projects that are coming on stream, and you've got some vessels actually here in Canada, Traversier du Québec, that run the ferry service across from in the St. Lawrence River, are building their 2 new ferries powered by LNG. And here we go. And I think we're up to, in the world now, we're up to, putting aside LNG carrying vessels, I think we're up to about 75 vessels, non-LNG cargo vessels that actually run on LNG. 75 is not a lot, but it's a start, and I think this is where the future is going to go, especially as we see regulatory compliance, especially when it comes to air emission quality, actually becoming more stringent. All right, so here's the $64,000 question. Why is this not being mandated? Is this not the perfect solution? Well, I wish it was that simple. There are challenges to LNG vessels. First of all, you've got to invest in the propulsion system. You can't just wave your magic wand and change a vessel's propulsion system from burning heavy fuel oil to LNG. Ship designs have to be reconfigured to deal with LNG fuel tanks. Where are you going to put the fuel? Many fuel tanks are on the deck of ships. Many fuel tanks are reconfigured in different ways. But one of the challenges, and you have to keep this in mind when you're talking about ship operations, vessels are floating revenue-generating assets. You put as much cargo on there as you can, and you run them as long as you can. All right? So if you have any piece of equipment, any storage tank, that is larger than what you really need, you're taking up cargo capacity. And what that means is that over time, you're reducing the amount of cargo the ship could carry, and you're reducing the amount of revenue you're generating from that piece of equipment. I think the studies show that LNG storage needs close to 2 times more, about 180% of a regular storage tank for heavy fuel oil to run the same vessel. So there's an efficiency issue, and there's a cost element to it. The biggest challenge, I think, and I know I'm running short on time, is lack of bunkering facilities. A bit of the electric car syndrome. Everybody wanted to buy an electric car, but where are you going to get your fuel, your electricity to run the car? There aren't that many LNG bunkering facilities in the world. Where we're seeing them is in areas where you've got dedicated trades. If you've got a ship that is operating worldwide, it's going to be a real challenge to have an LNG-powered vessel because that ship could be anywhere at any time. It could be in Southeast Asia, it could be in West Africa, it could be in North America, it could be in Northern Europe. If you've got a vessel, on the other hand, that's operating in a dedicated trade, and I think the corridor between the Montreal, the St. Lawrence River, and the Arctic is a dedicated trade. You've got ships that are specific to that trade. They run one course. They go from the St. Lawrence River up to the Arctic into the different communities. You have many dedicated trades like that in Europe, in the North Sea, in the Barents Sea, where the vessels, they could be ferries, they could be tugs, they could be cargo vessels that only operate within 2 ports. Where you've got a dedicated trade, it's much easier to focus on how you're going to refuel your ships. You can put storage facilities, and you know that ship eventually will be where the storage facility is. So I do see bunkering facilities developing, and I do see them first developing, as we're seeing now, in areas of dedicated trade. But again, same thing with the electric car. The more of these fueling facilities we see, the more we're going to start seeing regular worldwide operators whose ships are tramping around the world, looking at LNG as a means of powering their vessels. All right. What do we have in Canada in terms of regulations? Nothing. Right now, we've got some old regulations which deal with how ships are powered, but it really, the focus has been on heavy fuel oil. That having been said, I know there's an initiative right now going on at Transport Canada to revise the guidelines with respect to the use of LNG. There is, the IMO has come up with with an international code for the safety of ships using gases, another low flashpoint fuels, the IGF code. Canada is looking at the IGF code and seeing how that can be adopted into our own regulations. So we are going that way. But if you were to take a snapshot right now as to where we are, there are no regulations allowing for LNG-powered vessels specifically. All right, very quickly, ballast water. I think Peter went through it. I know there was a mention by Professor Wallace. One of the challenges, and here's, I guess, one of the hopes, is that although we've signed on to the convention, we haven't actually implemented, as Peter said. When we do implement it, I hope it sees the light in the Arctic as well. But there are challenges in the Arctic that we're going to have to deal with. One of the biggest challenges, I think, is equipment equivalencies. You need some specialized equipment if you're going to be imposing some of the regulations in the convention on vessels. And we're in a situation whereby the technology has not met up with the regulations. In other words, there is no standardized piece of equipment that could meet all of the requirements of that convention, and that's a bit of a challenge. All right, very quickly, Tanker Safety Expert Panel. This is something that was initiated back in 2013 by the federal government. I know I'm running out of time here, I know. I'll go through it quickly. They had 2 phases, one for the south and one for north of 60, looking at ship source oil pollution preparedness. with respect to the Arctic, there were 25 recommendations that were made, and the recommendations really dealt with prevention. How do we put investment in aids to navigation and ice navigation, and how do we prepare and respond? One of the initiatives now going on at Transport Canada is something called the Northern Marine Transportation Corridor. It is an initiative which focuses where the trade in the Arctic is. Arctic waters and the jurisdiction of the Arctic waters takes up probably 40% of the rest of, if you compare it with the rest of Canada, it takes up about 40% of our land and water mass, all right? But of that, there's only about 10% where vessels actually proceed. So rather than saying, well, you know what, only 1% of the Arctic is charted and we need to invest in charts, vessel charts. 98% of the areas which are not charted, vessels aren't going there anyways. So what Transport Canada is doing is it's do it by way of a study. It's actually focusing on where 80 and 90% of vessel traffic is, and by using that as a filter, as a prism, they're going to be filtering, and I think the idea is to then filter where the investment in terms of aids to navigation, in terms of port infrastructure, where those investments will take place. All right, got to move quickly. Okay, very last thing, wish list. I'd like to see a pollution spill response organization in the Arctic. Peter spoke about response. There are response organizations in the south. There is no response organization in the north. So if there is a major oil spill, I got to tell you, that's a problem. You've got some communities that have little tanks that can probably deal with small spills, but if you've got a major spill in the Arctic, we've got a bit of an issue. I'd love to see more LNG-powered ships in the Arctic. I think that's where we're going. And someone told me in the world, every 100 years there's a change in how vessels are powered. 200 years ago, we moved from steam to heavy oil, and rather from wind to steam. 100 years ago, it was a shift over to heavy oil, and now we're at that 100-year mark. And certainly the classification societies and many of the pundits are saying that now is the time for LNG. Last thing, extending ECAs up to the Arctic. And that, thank you very much.
Thank you very much, Peter. That's a massive topic and very well to get through. Could I begin with a question? This is one not precisely in what you've covered, but I know you have looked at this. The one that scares me to some extent is, in addition to the pollution control, where I did see a U.S. Coast Guard officer who referenced the Canadian capabilities for a major oil spill disaster, said the most important piece of equipment they had was a telephone to call the Americans, which I found quite difficult. But it's the cruise ships and the increasing. I know they played a fairly aggressive role at times in the Polar Code negotiations. We're trying to impose obligations for reception facilities that would allow them to visit small communities and to push the limits. But leaving the waste disposal aside, which they just go outside 12 miles generally and do it, we have the search and rescue problem. I mean, we had the Clipper Adventure or something it was in 2010 with 179 people on board, ground in perfect weather, with the Amundsen eventually getting there in about 2 days or so. They could take them all off. Now we have the ships like the Crystal Serenity with over 1,600 people. If they run into trouble in a situation of bad weather, there is no rescue possibility, really. If they have to wait 2 days or more for some kind of help. What is IMO thinking on that? What is the Canadian thinking on it? And how do we restrict that, apart from the pollution problems, is the sheer safety issue and the cost it imposes potentially on the coastal state, Canada?
Well, that's a good question, and it's not only a good question, but it does keep a lot of people at the IMO, certainly a lot of people at Coast Guard up at night as well. The issue with the Clipper vessel, you're absolutely right. It was six years ago, and they lucked out, very similar to the situation with the Explorer. The weather was great, and there was a Coast Guard vessel within 2 days away and took everybody off. Today, they're all talking about it. I'm sure they're sitting at home and wherever they are and speaking about their experiences. Thank God no one was really injured. But it's because of the concerns. That incident focused people's minds, especially with our friends at Transport and at Coast Guard. And I think that's probably why you saw the preparedness and all the advanced planning take place with the Crystal Serenity. We've read about the Crystal Serenity this past summer, going through the different communities. The stories have been, for the most part, very good. Is there room for improvement? Of course there is. If you imagine, that voyage was 2 years in the planning. Now, that means that if it was 2 years in the planning, it must have been on a line item in a boardroom agenda 3 years before the actual sailing. And over the course of the planning sessions, you saw the investment that companies like Crystal put into that voyage. This was not a situation, as we spoke earlier, about a rogue vessel. This is not a situation of someone a cruise company that's been operating in the Caribbean for the last 20, 30 years, knows a lot about cruising, about the cruise industry, but knows very little about the Arctic coming up and then finding itself in some trouble. I'm finding that the industry, especially with respect to Arctic shipping, is regulating itself. I think the mention was made about reputational risk. If something goes wrong, yes, you could talk about the cost of recovery. And just to answer your question specifically, Philip, I am very concerned that we may not have the resources to deal with a situation whereby a ship does get into trouble and there's heavy weather and the helicopters and the other ships can't get there in time. But on the positive side, we are seeing the cruise industry taking these issues more seriously and spending the money and the investment in actually planning their voyages in the Arctic. With support vessels, I mean, the Crystal Serenity had a support vessel alongside at all times in case something went wrong. I think as we move forward, I think we're going to be seeing more and more of that type of operation. I think underwriters are demanding it because once you've raised the bar in terms of what's needed to run a safe operation in the Arctic, then you're going to have people demanding that as an operator, you maintain that bar. Not only governments, but you're going to have your underwriters, your hull and machinery underwriters, you're going to have your P&I clubs looking at this and saying, well, hold on a minute. You're telling us you want to go up to the Arctic. You haven't really been an Arctic player. You don't really know the environment. But let's look at someone who's been up there already. Here's a perfect example of someone who's had 2 years of planning, and here's the investment commitment they made to it. And I have a funny feeling the industry itself will, whether regulations move quickly enough, I think the industry itself will find itself in a situation whereby it will have to comply with that higher bar.
Thank you. Aaron?
Thank you for an interesting presentation. I have a question, and I know that I'm not going to pick on this too much because I think you mentioned during your presentation you were intentionally being a little bit glib talking about LNG vessels and cleanup and basically how there might be a possibility of if there's a spill of sort of having a certain amount of laissez-faire attitude to the fuel itself sort of dissipating into the atmosphere. I guess my question is, as someone who'd never really heard of the idea of smaller vessels being fueled by LNG, which is an interesting idea, has anyone done modeling that you know of if there is a spill that comes from one of these vessels, what the relative impacts on climate change would be? It strikes me that if the methodology of cleanup is essentially letting a bunch of methane evaporate into the air and methane having a much higher, impact. If we move to this, I mean, one ship, sure, that's fine. But if we move to this as a model for shipping generally, globally, is this something that's been looked at?
Okay. Maybe I should have been clearer. I said I was exaggerating to make a point. I think it was more tongue-in-cheek when I was told just wait 30 minutes. The point I was trying to make is that the use of LNG and the impacts of a spill, an LNG spill, are less detrimental to the environment than if it was heavy fuel oil. Really for cleanup purposes and the immediate effects of the spill. I certainly didn't mean to suggest that we take a laissez-faire approach to any spill, even LNG. But to answer your question specifically, I'm not aware of whether there have been any studies on the environmental impact. I do know that there have been studies, a number of studies, mostly by classification societies, to understand how better to run LNG vessels, how to build them, how to operate them, how to equip them in order that to become more efficient. I've got to think, but right now I can't think of anything. But knowing how the industry operates, knowing how the IMO moves forward with respect to research of this kind, I've got to think that at some point, if LNG as a fuel becomes prominent. And as I said, at this point, 76 vessels, I don't think it's on anybody's real radar screen to invest money for research. But if it does become prominent, I certainly see more and more people looking at this and seeing whether or not what the impacts are to the environment on a spill, if there is to be a spill, an LNG spill.
I've got one question,
Yes.
Peter. I just
Yes,
have to ask, and it has to do with the Arctic Water Pollution Prevention Act and the Polar Code.
Yes.
Now, one of the sort of elephants in the room, well, I guess they don't have them in the Arctic, whales perhaps.
Yeah, polar bear. So the polar bear in the
Like
room.
polar bear in the room, is the whole question of jurisdiction.
Yes.
And that's largely been seems to me, we agree to disagree because there's not that much shipping, actually, foreign shipping. If indeed with climate change we see real potential there, then do the jurisdictional issues then become a little more acute and people start saying we're not crazy about where you draw your baselines, for example. And is the Polar Code designed to essentially circumvent that problem by saying, well, we all agree?
All right. First of all, you're absolutely right in that we're not really seeing. I mean, the Arctic navigation, certainly in Canada, is not really international. It's what we call destination voyages. It's mostly Canadians, ships going up for community resupply. I'd say that takes up a good chunk, and fishing, of course, fishing vessels. That takes up a big chunk of what we're seeing in terms of the Arctic. Specifically, to answer your question, I don't think the Polar Code actually addresses jurisdictional issues. At some point, we may get to a situation, and Suzanne is here, who's probably one of the leading experts in this area in terms of the Northwest Passage and you know the Canada Clause in UNCLOS, and how we must treat foreign vessels coming through our waters. And at the end of the day, it comes down to making certain that everybody's treated the same, and there are no preferences to Canadian operators or operators of a certain type. If it's an environmental issue, then as long as everyone is treated in the same way with the same regulatory regime, then I'm hoping that there's not going to be an issue as to whether or not Canadian rules should be complied with in Canadian waters. The only other thing, in terms of the Arctic Water Pollution Prevention Act, that as well doesn't deal with jurisdictional issues. But what is interesting, and what I'm waiting to see, Canada hasn't really come forward yet. We have said that we're going to be adopting the Polar Code, but we haven't really, and as I think Peter alluded to, we are also in this country going through a complete review of all of our Arctic legislation, all the legislation that we have in Canada that touches upon the Arctic. What I'm waiting to see is whether or not we actually up the game from the Polar Code. Polar Code has certain standards in certain respects, and I touched upon a few of them in my slides. In certain respects, the Arctic Water Pollution Prevention Act actually has a higher standard than the Polar Code. And I'm very interested to see whether or not Canada will, in fact, maintain that higher standard or will fall back to the standards of the convention itself. I'm hoping the former rather than the latter, but as I said, I haven't seen the regulations come out yet.
Thank you very much.
Thank you. Thank you very much.
We'll have a break now. We still have the 15. We're still pretty close. So if we can have a little break for 15 minutes, and we'll move on to the fish. Thank you.
and I wanted to show you this so you could see the big coast that we have out west, but also to situate the 4 cases I'm going to talk about. One's on the west coast of Vancouver Island, the big island at the bottom left, and another involves Haida Gwaii, the islands to the north, which are legally called Haida Gwaii, not the Queen Charlotte's anymore, by law, something that I don't think has caught on in the rest of Canada, but through the Haida Gwaii Reconciliation Act, the legal name of those islands is Haida Gwaii. And then I'm going to talk about a case involving the Heiltsuk, which is on the central coast, up right at the tip, northern tip of Vancouver Island, and some of the other central coast areas there. So the first one is about the Nuu-Chulnith injunction to oppose the herring opening. But this picture is not from that case. It is the celebration that occurred in the small water access only community of Ahuzit when this nation, the Nuu-Chulnith Nation's rights to commercially fish and sell fish were affirmed in court. It's the longest running Aboriginal fisheries rights dispute in BC, I'm assuming in Canada. The case started back in 2003. A judgment was rendered in 2009, over 300-page judgment, over 120 or 30 days of trial. And the court, that judgment was then appealed to the Court of Appeal, to the Supreme Court of Canada, went back to the Court of Appeal. Complicated case history. There's a little detail in the paper that I won't go into. And the trial judge in that case, Madam Justice Garson, now on the BC Court of Appeal, gave the parties 2 years to negotiate whether or not Canada's infringement was justified, because her judgment found that the cumulative effect of Canada's entire fisheries legal regime prima facie infringed the rights of the nation in question. So she gave them 2 years to go and negotiate. This was back in 2009, but unfortunately they weren't able to reach an agreement. And so the justification trial, I think it finished last March, but no judgment has yet been rendered. And I'm actually not even sure if the case is final, the infringement case is finally finished. But this is a picture of the gym in the Ahuzit, and apparently there was a party till 3 a.m. This is from the local paper showing how jubilant people were when they finally had their rights affirmed. The area was closed to commercial herring fishing in 2006 and remained closed up until 2014. And I think probably many in this room know at that point, DFO Science gave advice to the minister to keep the herring fishery closed, but the minister at the time decided to override this advice and open the herring fishery. So the plaintiffs in the Ahuzit case, the same ones who were involved in this long-standing fisheries rights dispute, applied for an injunction, in part because the minister regarded her own science advice. And here's a picture of a Nuu-Chulnith fisherman with the traditional herring roe on kelp. So you can see just an example of what that fishery looks like. The commercial herring roe fishery is not this traditional fishery, but I just thought you'd like to see that. So they were successful in obtaining the injunction, and the judge admonished the minister for fudging the numbers and said that once the minister and DFO depart from science-based assessments, the integrity of fisheries management system is harmed. These Nuu-Chulnith nations had put forward their own fishing management plans under their own laws, and they're still waiting to actually implement their own fishing plans. Unfortunately, this dispute continues, and just last month, the Nuu-Chulnith are tired of negotiating. They don't see the benefit, and they've asked DFO to leave their territory until the federal government was ready to negotiate in a more meaningful way, according to the First Nation. So there's a short video clip on YouTube which actually documents how the nation asked DFO to leave their territory. So that's one example. And the next example is from Haida Gwaii. This is another case of herring, and it's another injunction case. In 2015, the Haida Nation obtained an injunction to prevent the reopening of the commercial herring fishery. And this action has a long, long history. A small amount of it is detailed in the paper, but not much. In 2014, DFO had decided to open the Haida Gwaii herring fishery after years of sporadic closures. That year, the Haida decided, rather than seek court action, they decided to ask the commercial fishing industry directly to abstain from fishing. And again, the Council of the Haida Nation is the governing body in Haida Gwaii, and they passed a resolution under their own laws closing the herring fishery, and they asked the commercial fishermen to respect it. And they agreed. So 2014, they asked the fishermen voluntarily not to fish there. That happened. In 2015, DFO again proposed reopening the herring fishery in Haida Gwaii, even though the stocks were in worse shape than the previous year. And at that point, the Haida notified DFO that they were going to seek an injunction. And when DFO did not respond to their communication that they were going to seek an injunction, they did. And and they were successful. And the judge there found that the failure of DFO to consult adequately and the lack of a long-term plan to rebuild the herring population threatened to cause the Haida irreparable harm. And a major factor in that decision was also the series of agreements that the Haida have entered into with the federal government, as well as the province of BC, but mainly the federal government, about co-management. And the Haida Gwaii Reconciliation Act is an example of these agreements at the provincial Haida level, and then there's a number of agreements at the federal level, especially with regard to management of Gwaii Hannus, a National Marine Conservation Area Reserve, and Bowie Seamount, Federal Marine Protected Area, designated under the Oceans Act. So in that case, the judge agreed and found that the unilateral imposition of, quote, a highly questionable opening of the fishery constituted irreparable harm. And that's just a photo. I thought you would like to see some photos of the West Coast ocean people here in Halifax. So there's a photo of fishing boats out in Haida Gwaii. And the third example I'm going to turn to, we're moving away from using the courts to seek injunctions. This is the case of the Heiltsuk up on the Central Coast. And this First Nation's probably well known to people who have worked in the areas of fishing law, because this is the nation that brought forward the successful Gladstone case, which is the only other case in which a court has ever found that a First Nation has a commercial right to sell fish. So the Ahuzat and the Heiltsuk are the two cases, but Gladstone is the name of the case for the Heiltsuk. And this is, again, an example of an exercise of Indigenous law, the Heiltsuk Declaration of Title and Rights. Part of it states that they reaffirm the continued existence of Heiltsuk title. They're not seeking Canadian government recognition of their title. They're reaffirming their title that they've never given up. And in March 2015, this was, again, about the herring fishery. There's a lot of concern about herring on the West Coast, as you can tell. And there's concern that the way DFO assesses stocks and authorizes fisheries openings may not be cautious enough to conserve the fishery. So in March 2015, after negotiations about opening this fishery stalled, over 100 members of the Heiltsuk Nation occupied the DFO office, giving them a deadline to close the waters. Ultimately, DFO agreed, and the commercial boats did exit the Heiltsuk waters. And this was the eviction notice that they posted on the DFO door. And another photo from that confrontation. The Heiltsuk maintained their right to maintain the herring fishery, grounded in both Heiltsuk and Canadian law. And this story, though it doesn't involve a court decision, it is an enforcement case, and in 2016, to avoid another conflict, DFO and Heiltsuk tried again to reach an agreement about opening the herring fishery, and when they were unable to reach an agreement with DFO, they worked directly with the commercial fishing industry and reached a herring management plan that was later authorized or agreed to by DFO. And the terms of that plan included no-go zones, a significantly smaller catch, and prohibition of the night fishery. So this is the fourth case study, sort of zipping along through these examples. And this is the final one I'll talk about, is the Central Coast crab fishery closures. There's a picture of a crab. In 2014, 4 Central Coast nations, the Heiltsuk, Kitasoo, Hei, Newhalk, and Wikinew, enforced their indigenous laws by declaring crab closures in their waters. They were concerned about the declines in Dungeness crab populations along the coast and frustrated by the lack of DFO presence, especially enforcement presence. The nations decided to conduct their own research on the crab populations. And from discussions I've had with members of this nation, they would often see commercial fishing boats leave crab traps in the water longer than the allowed amount of time, over 10 days, and they'd notify DFO and say, look, there's a bunch of crabs out here in our area, Kitasoo Bay or wherever it might be, can you please come and investigate, but had difficulty getting an enforcement response. So they started this study, which has been written up in a scientific journal, and the aim of the closures was to determine whether commercial and recreational fisheries were contributing to the decline in Dungeness crab size and numbers. And this photo is of 2 of the Wikinew Guardian Watchmen collecting data for the project. And I'll speak a bit about the Guardian Watchmen. DFO chose not to communicate these closures or recognize them, but again, the nations communicated the closures directly and asked for compliance from commercial and recreational fishers. And over a 2-year period, the study showed that both the body size and the numbers of Dungeness crab increased at the closed sites, and there was a high level of voluntary compliance by the commercial fishing industry. And meanwhile, at the open sites, the size and population of the crabs decreased. And again, unfortunately, this fishery remains in dispute, and this is actually just from last week, and it's carrying on this week. The Heiltsuk have again closed the crab fishery in their waters using their indigenous legal authority, and it looks like a confrontation is coming or is already happening. And these are just, I just took screenshots of tweets from Jess Housty, a member of the Heiltsuk Nation who works in the fisheries department. So you can see that there's a number of disputes. I've just touched upon 4 here. And there's a number of responses, and due to the shortness of time and the complexity of this issue, I only have time to talk briefly about 3 of the responses that the Canadian legal system have made, and just sort of touch upon the surface. There's many more other possibilities of ways to go to attempt to better reconcile Indigenous fisheries law and Canadian fisheries law and authority. And so there are negotiation of memorandums of understanding underway between DFO and individual First Nations. We also have a very good success story on the BC coast, north and central coast, of marine spatial planning. Someone was asking about area-based management. I think these Marine Planning Partnership, or MAP plans, are a significant achievement. They're the first large-scale ocean integrated management zones in Canada, and they're quite impressive, mapocean.org. But I'll talk about these 3 responses. The first is the Guardian Watchman, which I already mentioned. This is a type of enforcement authority that the nations of the North and Central Coast have put together. No taxpayer dollars involved. It's largely funded through charitable contributions, and it's part of this Coastal Stewardship Network and Coastal Nations Great Bear Initiative. It exists. It's not, authorized by the Canadian government. It's a partnership between nations, and it was created primarily as an enforcement agency. And they have different titles for the Guardian Watchmen that range from resource technicians and fisheries guardians to park rangers and community watchmen. And they're out on the water every day. They have a really interesting app, Coast Watch app, where they log data about observations as well as violations, and they've been very successful in getting eyes and ears on the territory every day. And you may have seen just recently, again, this is a very newsworthy topic, I feel. Just last week, actually, the Guardians held a national gathering in Ottawa. Guardian Watchmen started in BC, started in Haida Gwaii, but the concept exists all across Canada of having an Indigenous enforcement agents and people to enforce Indigenous laws. And last week in Ottawa, the Guardian had a press conference and said that they were seeking $500 million from the federal government for 1,600 Guardians, maybe you'd like that many more new on your staff, to patrol and assert Indigenous authority. And there are successful examples in Australia in particular of Indigenous rangers, and there are studies that have shown that the Indigenous rangers actually have led to improved social and economic conditions for Indigenous people in Australia, and that was part of the pitch to the federal government. So that's one possible response. Another response is co-management boards, formal co-management boards, and these could be about fisheries, or they could be more broadly based to deal with ocean resources. We do have this example of the Archipelago Management Board in BC. It was set up to manage Guayhanas, this very large national park and now National Marine Conservation Area and Reserve, and it's tasked with developing ecosystem objectives in addition for fisheries in particular. Even though the Minister of Fisheries and Oceans retains ultimate authority over fishing in Haida Gwaii waters, this Archipelago Management Board does make recommendations about fisheries conservation objectives. And the AMB did get involved in the herring dispute in Haida Gwaii, but that's a long story too. So I mentioned other examples of fisheries management boards. There's a number of them, a lot in the Arctic. And then the last potential, the last response that we have right now in the Canadian legal system is to recognize Indigenous law authority directly under the Fisheries Act. So we have this Section 5.4 of the Fisheries Act, which allows powers to certain Indigenous, powers to enforce directly Indigenous fisheries laws for those 4 named First Nations who have settled treaties. So that's a unique feature of the law, and it is possible that this type of arrangement could be extended to other nations as well. And so the Nisga'a is one example. They were the first settled land claim in BC, and they're up in northern BC. The Nass River drains into the Pacific north of Prince Rupert, and they have their own fisheries law and quite established fisheries management authority. So, getting near the end, now that we have the review of the Federal Fisheries Act going on this fall and winter by the Fisheries and Oceans Standing Committee, it is an opportunity to bring up issues like expanded co-management rights as one example, in addition to strengthening habitat and lots of other potential changes that could be made to the Federal Fisheries Act. So, in conclusion, this very short discussion highlighted recent conflicts between Indigenous and Canadian federal government management of fisheries. And the cases reflect a state First Nations conflict as well as competition between these different but increasingly intertwined legal traditions. The goal of this talk was to ask you practitioners to consider how Indigenous legal traditions can play a role in fisheries management and conservation. So just to consider this idea and consider this possibility. And as mentioned, the Truth and Reconciliation Commission has a number of calls to action for the entire Canadian public. And it called upon the government, as one of the examples of the calls to action, to use UNDRIP, the UN Declaration on the Rights of Indigenous People, as the appropriate framework for reconciliation in the 21st century, and to review our laws to see how well they accord or don't accord with UNDRIP. Finally, to end, ultimately Indigenous legal traditions can and should play a critical role in fisheries management in Canada. Thanks.
Thank you very much, and a lot of ground covered very quickly. Sorry. Unless somebody has a question ready. Okay, I'll start with one that, oh, we have one here.
Hi, Linda. I know you're going to be able to speak very much about the BC experience. I'm wondering in your discussions or even in your experience with this, to what extent there was any looking at the joint management experience, particularly for fisheries in northern Canada, whether Yukon, Northwest Territories, and Nunavut, and also some of the experiences in northern Quebec and Manitoba. It's not based from the same legal background, but there is the practical result of a joint management approach.
Yeah, great question, and haven't really looked in depth into those other examples, just sort of touched on the surface. But we have done research on especially the examples in Quebec and some about the co-management boards up north. And I think it's just an interesting topic for everyone who's involved in enforcement to be aware of, about how much is already going on in Canada. But any particular examples of the direction that the Guardian Watchman should go in, or other nations and how they pursue enforcement, are very welcome.
Okay, I'll end with one question. It's an area of real interest that the extent to which you can integrate pre-existing or developing management traditions from something outside the formal statutory context. In some places it's worked well, in other countries, and others it's not, because the difficulty, particularly in enforcement. Is there something you see in particularly these two nations that would give you an idea of criteria for where you might be best able to implement true co-management schemes or even independent management schemes? That might be a bit broad, but it's of interest to other parts of the country, I suspect.
Mm-hmm. Well, I think those Indigenous nations that have actually never signed treaties, like most of BC, and have consistently maintained their legal authority to manage their fisheries, and have consistently objected to the imposition of, for example, licensing under the Fisheries Act, for outlawing of traditional technology like weirs, outlawing of potlatches. Those nations that have maintained this consistent position since settlers arrived, I think that's one criterion maybe for success, is that they've just strongly guarded their traditions and their laws and have enforced them over the past century and more. Another criteria is a strong government within the nation. Another criteria might be how interested the nation is in bridging between their own legal traditions and Canadian legal traditions in co-management, because I think there's a lot of possibilities for these bridging instruments. And the MAP plans that I mentioned, the marine spatial plans, those to me are an example of a bridging mechanism, because they are they're voluntary plans. They don't have much of a statutory basis, but they're based on Indigenous legal principles as well as Canadian legal principles. And so I think there's, if nations are interested in pursuing that type of arrangement, I think there's better chances of success for co-management.
One point I was interested in, Linda, and that is because we talk a lot about it these days, is traditional environmental knowledge, and the scope that this sort of regime affords for that. Has that proved in fact the case, that there's a greater willingness to use it, and in fact is used more?
Yeah, I mean, I think a lot of Indigenous peoples and First Nations don't really like this separation about their traditional knowledge off on this side compared to Western science off on that side. They seem, much more about different ways of knowledge and experiencing the world as being able to inform conservation and management. So in the Central Coast crab fishery closure, I mean, yeah, they picked their sites for closure based on traditional knowledge about where they thought the potential would be to regenerate crab populations. And I think it's a big feature in all of the cases, is that they are asking for greater caution in fisheries and shellfish management based on their traditional knowledge, their experience over, many, usually hundreds of years, and the conflicts arise when their knowledge or science isn't as valued as stock assessments or other tools used by DFO that are maybe very scientifically grounded, but don't actually always work, as we see, and as we certainly saw here on the East Coast with the cod collapse a number of years ago.
Thank you. Wonderful presentation. I've got a question, and with respect to where we store traditional knowledge, or how do we manage it? The situation up in the Arctic is there is certainly a tremendous push to somehow try to encapsulate all this traditional knowledge, because over time, what's going to happen with the knowledge if you don't actually capture it? And I know centers, for example, there's a center in Igloolik up in Nunavut that is focusing on being the repository, if you want to call it that, of traditional knowledge, Inuit traditional knowledge, so that we can go back in later generations and see what the elders used to say, and what the information was with respect to the land. Is there an effort to at least try to capture a lot of the traditional knowledge, and are there calls for the creation of a center to capture that traditional knowledge for posterity?
Yeah, great question, and there are different initiatives that I'm aware of, and there's probably a lot more that I'm not aware of. So for to start off with, a lot of these societies had oral traditions, so they don't have a written record of their knowledge. So doing the hard work of interviewing elders and recording it in written form and then putting in a repository is a first step. That takes money. That's part of, I think, the Guardian Watchman is that would include this initiative that's gone forward to the federal government, is to get more funding so that the Watchman can do the types of interviews. My organization, West Coast, has a program called RELAW, which is about revitalizing land, air, and water for Indigenous societies. And we're working with 6 First Nations, 6 pilot First Nations, to do just that, to draw out the knowledge, put it in written form, working with community members paired with a lawyer or a law student and others, and then sharing the knowledge with each of the 6 nations, and also recording it. Making it public has some issues, depending on the type of knowledge it is. If it's about sacred sites, it might have a certain sensitivity. If it's fisheries data, we know that there's confidentiality from, that can be involved in that too. The map process, again, that I mentioned, the BC Marine Conservation Atlas, did compile both the Western science and traditional knowledge as far as possible, and that's all online and available, and I think is a great resource. And I'm sure there's lots up in the north that I'm not aware of, but I think it's really useful. And for project proponents like you might be involved with or represent, I think it would really help the project approval process, or project siting or decision-making process work a lot better if there were those types of resources available.
Thank you very much. Thank you. And we're moving along reasonably well. And our next speaker is Will Moreira as a partner at Stuart McKelvey, and more to the point, one of our most prominent practitioners in the areas of both admiralty and fisheries law for many years now. So I'm going to leave it to him, but the topic is Fisheries Act as an environmental protection statute, which carries on from some of the things we've been talking about.
Thank you, Phil. It will surprise all of you after today's sessions to actually learn that the Fisheries Act is an environmental protection statute. I was thinking just a few minutes ago, I've heard more about the Fisheries Act today than in the last 30-some years of continuing education. So thank you for caring. Thank you also to Peter Cullen for introducing me as a former president of the Canadian Maritime Law Association, as indeed I am. What he failed to mention is that he was my immediate predecessor as president of that association. So due credit to you as well, Peter. I'm sure he didn't mention that, so as you not to have you worry which of Peter and I is the older. So we'll tell you after the session if we have time. The day job of the Fisheries Act is the regulation of fishing, the fishing industry, the commercial fishery, and subject to being, what I'll say in a non-emotive way, supplemented by indigenous legal principles, as Linda has just described, aboriginal fisheries. The Fisheries Act, however, has a section on protection of habitat, which is where its use as an environmental protection statute comes from. Let me just introduce these remarks. I know you don't have the papers. If you're interested at all in this subject, my own paper, which I believe is available online or will be, is basically a review of the last 10 years or so of jurisprudence and where reported decisions are either not available or not the best way to learn of enforcement announcements from Environment Canada's website. And if you're at all interested, please refer to my paper for the detail, because I'm not going to dwell a great deal about what's in it. But the theme of my paper is really threefold. One is what the Fisheries Act can't do in way of environmental protection. Secondly, what the Fisheries Act is not really very suitable to do, although it's used. And lastly, what the Fisheries Act has apparently ceased to do in the way of environmental protection. So please bear with me as I struggle through those. What the Fisheries Act can and conversely can't do is limited by our Constitution. And the constitutional basis for the habitat protection provisions in the Fisheries Act is Section 9112 of the Constitution Act of 1867, which is on your screen there. It is lawful for the federal government to make laws coming within the class of subject seacoast and inland fisheries. And that restricts the scope of application of this particular piece of federal environmental protection legislation to the requirement that there be a nexus between the prohibited conduct which has given rise to the case under consideration and the fisheries. The scope of that power was first considered in a couple of cases in 1980, Northwest Falling Contractors and Fowler. Thank you so very much. I didn't read my paper closely enough or recently enough. In Northwest Falling Contractors, the facts were that a fuel pipe broke on a fishing dock in a bay and spilled diesel fuel into the waters of the bay. The owners of the dock were prosecuted. The case went to the Supreme Court on the question, was this a valid use of the Section 9112 federal power? A unanimous Supreme Court, with Martland J. writing the decision, said yes, it was, because the purpose of the prohibition was to protect the fish which lived in the bay and which supported a fishery. The business end, or what has become the controversial sentence, less than a sentence, from Northwest Falling Contractors is on your screen, where Martland J. said that the case does not involve the question, and so he didn't answer the question, whether legislation would be valid in facts in which the scope of its reach extended or was purported to extend to waters that would not in fact be fisheries waters. And as we'll see, that was interpreted, not often, but when it arose in later decisions, to mean that there could be waters in which, or waters that were not in fact fisheries waters, to which the Fisheries Act could not constitutionally validly apply. One such case was Macmillan Bloedel in the British Columbia Court of Appeal in 1984. The charge was under what used to be the HAD prohibition, harmful alteration, disruption, or destruction of fish habitat, to which will come when I come to things that the Fisheries Act has apparently ceased to do. But a logging company had fouled, to use the non-legal term, waters in a remote creek on Vancouver Island, which, although inhabited by fish, was a place in which no fishing was carried on, neither commercially nor recreationally. The BC Court of Appeal, interpreting this passage from Mr. Justice Martland, waters that would not in fact be fisheries waters, found this creek to be such a place. Because there was no fishery in these waters, the Fisheries Act could not constitutionally apply, and therefore Macmillan Bloedel was acquitted. Because of its unusual facts, water with fish but no fishery, or proof that there was no fishery, this issue didn't arise very often, but it did arise in the Northwest Territories Supreme Court in 2002 in PHP Diamonds. To make a very long story short, a diversion channel was dug between a couple of lakes as part of the development of a mining project. The mine developer was prosecuted both for alteration of habitat in the creation of the channel itself, and also for deposit of a deleterious substance, the Section 36(3) offense, which Heather spoke of earlier today, because of the sediment that was carried downstream into one of these lakes. It was argued by the accused that there was no fishery in either of the two lakes which were joined by this channel. Therefore, on the authority of Macmillan Bloedel, it was entitled, the Fisheries Act did not constitutionally apply, and the mine developer was entitled to an acquittal. The Northwest Territories Supreme Court disagreed with the argument and expressed its disagreement with the decision in Macmillan Bloedel, saying the presence of fish alone is sufficient to attract the constitutional application or the constitutional validity of the Fisheries Act, and therefore the Act did apply to these two lakes in the Northwest Territories. As discussed in the paper, the problem is that perhaps that disagreement with Macmillan Bloedel is itself obiter dicta, for those of you who are not lawyers, something that is not necessary to support the court's decision and therefore of questionable authority, because the court ended up acquitting the mine developer in BHP Diamonds for other reasons. So there's been later consideration of both of those decisions. One in the British Columbia Provincial Court, which has declared itself bound by the Court of Appeal decision in BC in Macmillan Bloedel, and another by the Superior Court in Ontario in a case called Zuber, which acknowledged the existence of both decisions but didn't find it necessary to choose which of them was correct. So for the constitutional junkies among you, there's your afternoon fix. Section 36(3) is the section of which Heather and Armand talked to us this morning about the prosecution of the aquaculture company in New Brunswick. The point to be made here is that this is historically, and it remains, the vigorous and the relevant section of the Fisheries Act where prosecution for pollution is undertaken. It's by no means the only statute enforced by Environment and Climate Change Canada, excuse me. It has, as Heather spoke of this morning, a great many other statutes in its toolbox, I think is the phrase. But certainly one very vigorously applied where the facts justify it. And the proof challenges that face the Crown and that face the investigators when a prosecution under Section 36.3 is in contemplation were made very apparent in that presentation this morning, and I won't go into them. Section 36.3 is relatively infrequently used in connection with the pollution of tidal water. And there's basically two reasons for that. One is that, there's one primary reason, which is that most marine, in the sense of oceanic pollution, is ship-sourced. And there are much simpler anti-pollution statutes that apply to ships than Section 36.3, which are typically used under the Canada Shipping Act. All that is necessary to prove is that the substance was a pollutant and that the source of its discharge was a ship. And if you can prove those two things, then you attract equally serious penalties under the Canada Shipping Act. That's not to say that only the ship is exposed to prosecution. The owner can be, the officers and crew of the ship can be, if it's demonstrated that they were complicit or had that their actions were causative of the discharge. But it tends to be a simpler and therefore more efficient avenue of prosecution than Section 36.3. The more frequent use of Section 36.3 is in pollution of fresh water, typically by industries as opposed to by ships. Although, as we saw this morning, it certainly was used to prosecute a participant in the aquaculture industry in a case involving pollution of salt water, and it can be used where there are reasons that resort can't be had to the Canada Shipping Act or to other acts that apply specifically to shipping. And there's a review of the recent decisions and the recent prosecutions in the paper. I do want to focus, though, on the use of Section 36.3 in a very specific context, and that is the question of derelict ships. I think Owen asked this morning, what about orphan wrecks? And someone said there weren't many. Well, there may not be, but there's a wicked number of derelict ships, either abandoned or, even if interacting in some way with some human being that might or might not be the owner of this derelict, are neither operative nor in any financial position to keep themselves in repair or in operation. In the Newfoundland Recycling Limited case, a ship was in the process of being deconstructed at a pier, and the deconstruction had happened over, please let me find my notes, over, I think, a 9-year span from time to time. And eventually, the partially deconstructed ship sank at the wharf, causing a discharge of oil from the sunken ship. The accused was not alleged to be the owner of the ship. It was not clear who the owner was. But the accused was the contractor who had been hired by someone who might have been the owner 5 years before, to scrap the ship. And the scrapping contractor was prosecuted under Section 36.3 for permitting the deposit of the deleterious substance, i.e. oil, into the water frequented by fish, the bay on which this wharf stood. And the contractor was convicted. The defense of the contractor, or the defense attempted by the contractor, was that it was under no contractual duty to care for the ship. And the Newfoundland Provincial Court, and ultimately the Newfoundland Supreme Court, said, doesn't matter. You're in a position to take steps to prevent the ship from seeking and to discharge a pollutant. Regardless what the scope of your contractual duties may have been, you did not take sufficient preventive steps, therefore you permitted the discharge, therefore you're guilty under Section 36.3. I don't, in the report of the decision of the Newfoundland Supreme Court on Appeal, it does not say what the penalty was. But the problem there, I suggest to you, is the use of the Fisheries Act to prosecute the scrapping contractor is a disincentive to people to undertake the deconstruction of derelict ships. This was a derelict ship. She was an ex-Korean fishing boat. No one knew how she had come to this particular place in Newfoundland, nor what her owner, whoever it may have been, had intended to do with it. And I want to digress for a couple of minutes to talk about derelict ships and about why they are a serious environmental problem, why there is no immediately apparent statutory solution to the problem. The practical solution to the problem is to scrap the ships. But almost by definition, these ships are owned by people who either can't or won't spend money on the ships because they have no further purpose for them. They are not insured typically, and they sit there and be derelict until, as perhaps is inevitable, some pollutant is discharged from them, and action has to be taken. Peter Cullen spoke this morning of the Ship Source Oil Pollution Fund as a Canadian institution, the purpose of which is to pay compensation to people damaged by specifically oil pollution from ships, where that compensation is not available elsewhere. And more, the work of and the claims against the Ship Source Oil Pollution Fund involve derelict ships. The Coast Guard is empowered by statute. In fact, it's required by statute to respond to a pollution incident where neither an owner nor an insurer are taking steps to do so. And it is empowered to claim recovery of its costs from the Ship Source Oil Pollution Fund. The annual report of the Ship Source Oil Pollution Fund is a really good read. And I say that in all sincerity. There's a bunch of really neat stories of how things can go wrong and how difficult it is in some cases to respond to those things that have gone wrong. The most recent report of the Ship Source Oil Pollution Fund, and this is not in my paper, was published only over the Thanksgiving weekend. It wasn't there Friday and it was there Tuesday. In paper? It went online, it was there Tuesday morning, ssopfund.ca, if you wanted to see it. It's a good read. I want to read you some extracts from the fund's reports, just to give you a sense of the scope of this problem. The ship involved in Newfoundland recycling was a ship called the Sam Won Ho, ex-Korean fishing boat. This particular extract is from the 2006 report of the Ship Source Oil Pollution Fund. On April 12, 1999, the vessel sank at its berth with resulting oil pollution. An inclusive offer of settlement was made to the Canadian Coast Guard in the amount of $80,000. There was a further pollution from this wreck on April 24, 2000, and a claim from the Crown on behalf of the Canadian Coast Guard, which was settled for $36,000. They then talk about the fact that the deconstruction contractor had been prosecuted. And when this particular episode was reported in the report, it wasn't yet known what the result of the prosecution would be. From the 2014 annual report, there's a case called Emerald Tide, an abandoned pleasure craft sinking near the fuel dock at Port McNeill on Vancouver Island. The Canadian Coast Guard responded, filed a claim against the Ship Source Oil Pollution Fund, which was settled at $122,195. And here in Nova Scotia, in Bridgewater, just down the coast, the 2015 annual report speaks of a ship called Cape Rouge, a former fishing trawler, sank at her berth on March 10, 2014. There was a pollution response by the Canadian Coast Guard. The Canadian Coast Guard filed a claim with the administrator of the Ship Source Oil Pollution Fund, which was settled at $358,117.79. want to skip ahead. Cormorant, an ex-Canadian Navy ship, also in Bridgewater, listed heavily in March 2015. The Coast Guard responded to clean up the pollution. The claim against the Ship Source Oil Pollution Fund was settled for $515,267. In Shelburne, somewhat further down our coast, this is all from the 2016 annual report that came out over the weekend. Farley Mowat sank at her berth, again in the process of being deconstructed. On June 24th, 2015, the Coast Guard responded to raise the wreck and to clean up the pollution. That claim has been settled at $814,815. Very, very expensive responses. Oh, there's one other little thing I wanted to mention, if I can find it quickly. This is also from the most recent annual report involving a ship called Bromada, which is described as an old fishing vessel at Ladysmith Harbor built in 1926. And it gave a pollution response. The point is that locals, this is from the report, locals have named the cluster of decrepit, derelict vessels currently in Ladysmith Harbor as the, quote, dog patch. Some sense of the scope of the problem which these ships represent. The Ship Source Oil Pollution Fund, by statute, is able to and is required to respond to compensate the person, usually the Coast Guard, which spends money to clean up the particular discharge of the particular pollutant, but generally speaking does not remove the problem by deconstructing the ship or for paying for the deconstruction of the ship. There are cases out on the West Coast where they have paid deconstruction bills where this is essentially the only technical available procedure to deal with the, to prevent the pollution, typically with old wooden ships where the wooden structure is permeated with oil. But this is a significant drain on the resources of the fund for event-specific expenses which don't serve to eliminate the problem and the growing problem and the growingly expensive problem of these derelict ships. I go through all this in the context of the Fisheries Act by circling back to Newfoundland Recycling Limited, by saying that the Fisheries Act as an environmental protection statute does not give authorities the resources to remove the problem by deconstructing the ships, and as I suggested to you at the start, prosecuting the scrapper, as was done successfully in Newfoundland Recycling, may actually be a disincentive, even where, as in this apparent case, the owner had money with which to pay to scrap the ship. If the scrapper is going to be at risk of prosecution for causing pollution if something goes wrong. Lastly, I'd like to speak about Section 35(1) of the Fisheries Act. Old Section 35(1) is at the top of that slide. It was enacted in 1977. No person shall carry on any work or undertaking that results in the harmful alteration, disruption, or destruction of fish habitat. We call this the HAD prohibition, for the acronym for all harmful alteration, disruption, or destruction. Very vigorously employed, both in inland and in marine waters, at least on the foreshore, in cases, for example, of infilling without the necessary environmental assessments and permitting. In the omnibus bill, someone mentioned this morning, I forget the context, the 2012 Economic Action Plan, which of course involved omnibus legislation in affecting a great many environmental federal statutes, one of which was the Fisheries Act. And one of the things that bill did was create a new Section 35(1), which is at the bottom of your screen, requiring that there be serious harm to fish that are part of a commercial, recreational, or aboriginal fishery. And then defining serious harm to mean the death of fish or permanent alteration to or destruction of fish habitat. When I was asked to give this presentation about the environment, the habitat protection provisions in the Fisheries Act, I thought, great opportunity. It's now 4 years since that section came in, 3 years, sorry, since that section came into force. One will see what's happening in way of prosecutions under the revised HAD section, and I couldn't find a single one, neither reported by the courts nor posted in terms of a successful prosecution on the ECCC website. I conclude that for whatever reason, this section has ceased to be vigorously used. Because even though, as was explained to us this morning, complex prosecutions of sophisticated polluters take a great deal of time to get underway and then to reach the courts, routine prosecutions of ordinary people or even of smaller businesses who alter or disrupt or destroy fish habitat by their properties used to happen all the time. Usually were settled in terms of a plea agreement and a conviction and fine relatively promptly and reported, at least on the website, almost immediately thereafter. I'd be interested to know why between November 2013 and now there have been no reports of successful prosecutions under the new Section 35(1). Maybe it is felt not to work as well as the old Section 35(1) did. There is one judicial comment on the new section, a case called Courtouré in Canada. This was a fascinating case. A judicial review application in federal court by the chief of a First Nation seeking a judicial review remedy in respect of the introduction of the omnibus legislation in Parliament on grounds that there had been inadequate, in fact, no consultation with his community on, among other things, the change to Section 35(1) of the Fisheries Act. The court gave declaratory judgment that the consultation should have been held and was not, but granted no other remedy because the legislation by then had been passed and couldn't be unpassed. But in the course of its decision, the court did remark that the amendment to Section 35(1) of the Fisheries Act clearly increases the risk of harm to fish, which is one of the complaints that the applicant for judicial review had complained of. What the Fisheries Act, I suggest to you, can't do, oughtn't to do, and no longer does. And I hope that's been of some use to you. Thank you very much.
Thank you very much, Will. I just start with one small question. Maybe this isn't fair, but I will anyway. When you say that it appeared to you, and I think you've probably shown it more clearly than anyone else I've seen yet, that 35(1) in its new iteration was not being used to protect fish as aggressively or fisheries. Would it be fair to say, in addition to the federal court, that in that sense it fulfilled the objective that was behind passing the legislation?
I never talk politics with people I don't know, not even my former professor, speaking of who's older than whom. But just a minute. I would say not. I would say that one can equally, and there's some discussion of this in the paper, one can equally read new Section 35(1) and 2 sub 2 together as providing clarity, not diminished content. The clarity is, in the old section, what words did harmful qualify, and when did you have enough harm to engage the sanctions for which this section provided. And further, The new section applies to work, undertaking, or activity, which I suggest to you is necessarily broader because it's more words than the former work or undertaking. So I don't know that it was necessarily an environmental retreat, okay, or a throwing habitat protection under the bus. I think that's how it has been perceived in practice. One other thing that is in the paper, but it was not on my slides, on the DFO website, there is now a lengthy and very complex permitting process under the new Section 35(1). And if, I don't have the magic words right in front of me, but some activities are exempt from the requirement for a permit. And on the DFO website, there's a very lengthy guidance document of stuff that doesn't need a permit, and therefore please don't bother us with your applications for permits. And an awful lot of stuff that used to potentially engage prosecution under Section 35(1) is now exempt from the permitting requirement under the new Section 35(1), particularly work in the lake around your cottage, which was a real risk that ordinary people took interfering with habitat in cottage properties. That now seems to be, I won't say removed, but some scope. For example, you can dredge to this depth, or you can build a wharf of that dimension without having to get a permit under the new Section 35(1). I believe there's someone in the room who knows the answer to this question.
Well, I'll just say that's an extremely fair-minded response, actually, I think. And
Well, I'm on the
let's
defense
take
side, of course, of all
Of course,
this.
yes.
I agree with you. People don't talk enough about the Fisheries Act, and I could spend days and days doing that, so it's always nice to hear it from someone else too. But just to your point about not finding any evidence of prosecutions on the Environment and Climate Change Canada website, we don't enforce 35(1), and we never did. We do 36(3), so we do the water pollution portion. What you're talking about there is a habitat thing, which was always done by DFO and will always be done by them. So you wouldn't find it on our website. It doesn't mean that your point isn't correct, though. I would suspect that there would be fewer prosecutions. I don't think that the intent was really to abandon that space environmentally, and I'm not going to speak on behalf of them because it's not my mandate, but there was an intent, from what I've perceived, to narrow the scope of their jurisdiction so that they would focus on only the really big things, so that there wouldn't be a lot of time and effort spent on the smaller scale harm that maybe wasn't of a level that really needed the attention of the federal government. You mentioned cottages and things like that. They really wanted to focus the work of the department on much bigger things where they were really necessary. So it's possible that you will see a drop in prosecutions, but where I would suggest looking for that is the Fisheries Act annual reports, which should be available online, would probably have that all outlined in there.
Thank you. I'm grateful for that correction, and I apologize if I've misled any of you by looking at only one website from officialdom in preparing my paper.
Thanks very much. I just had to jump in on that because, in fact, there have been 0 prosecutions if you look at the DFO site and their annual reports. And apparently the latest one is coming out in the next couple of weeks. And apparently, again, there are 0 prosecutions for the habitat provisions. So you are right, even if you.
I am right, but for the wrong reasons.
And I and also I think your response and Heather's response were very. I'm not sure they went far enough to explain the situation, because access to information requests did reveal that the changes were made at the request of industry. And exact language was provided by a number of different industry associations and adopted by the federal government. And I don't think that's a coincidence. I'll leave it there.
Never talk politics at CLE. Was there someone else? I'll have to find my thank you slide.
Thanks. I'm going to change gears and make it not political.
Please speak up.
I said I'm going to change gears and I will not ask a politically oriented question. We've been talking a lot about prosecutions, but we don't actually have anybody here from the Public Prosecution Service of Canada who deals with charge approval. And you made a comment in speaking about the derelict ships that you think that the prosecution of that Newfoundland scrapper could have created a disincentive for those companies who could actually help the environment by removing a derelict ship. Do you think that there is a role to play in sort of appealing to the Crown during the charge approval process to say to them this is not in the public interest for these reasons in the absence of, since there's a bit of a vacuum in dealing with derelict ships? So until the federal government or somebody else deals with derelict ships, it's not in the public interest to create a disincentive for derelict ship scrappers?
The suggestion that this is a disincentive was my own original thought. I don't see that either a court or officialdom is there. I think the greater disincentive to dealing with the problem is a lack of money and a lack of insurance by the people who, for whatever reason, own these things. The point, though, I wish to make, and I went through these, large amounts of money in the most recent report, is this is a drain on the still very considerable resources of the Ship Source Oil Pollution Fund. I think I read in the annual report that the balance of the fund at March 31, 2016 was something like $400 million. So there's a lot of money there. But the purpose of that money is to respond to things like the Erica or the Prestige or the major industrial casualties that Peter spoke of earlier today, and not to, I suggest, result in bookkeeping entries within the Consolidated Revenue Fund, or whatever those accounts are called, so that this much money moves from the SOPF ledger to the Canadian Coast Guard ledger. That doesn't seem to me to be addressing the problem. I speak from the defense side in saying that, and I hope you'll all accept that there's other points of view. Derelict ships, there is actually a discussion paper out there from Transport Canada now on derelict ships. It's a significant gap in our shipping legislation and in our environmental legislation. The problem, to repeat myself, to deal with is who's going to pay the bills. I don't know what the answer to that problem is.
Yeah, that's actually a good point. And I'd add to it that in some cases it involves as well the mistreatment of crew members who are abandoned with the ship. And in some cases there have been people that have had to be sent home. And
Yes, yes, there have.
Slightly different issue, but it's
Slightly different issue. There's probably a greater chance that if the ship has come in and become derelict with crew on board, there's probably at least enough P&I insurance to
Yeah.
get these poor people home. That would be one's hope anyway.
Yeah.
The lady down the back there,
or the charitable.
or the mission who has funded such things. Sure.
Thank you. That was really interesting. Just wondering if you might be able to crystal ball a bit as to what potential changes are in the upcoming new revamped Fisheries Act.
I don't have enough fingers to count the number of revised fisheries acts that have been introduced in the years that I've been practicing fisheries law. I honestly haven't even read this one, so I don't know if it exists yet in bill form. The Fisheries Act, and I say this with 30-some years of practicing fisheries law, I got into this business defending Soviet trawlers in the 1970s. There aren't too many people who can say that. But the Fisheries Act actually works quite well. And it's not that it's the most wonderful of statutes, but the industry, at least, understands it and understands what it can and can't do. And I think it's fair to comment that a relative degree of regulatory certainty is a desirable thing, even if one doesn't agree with all of the substance of the regulations. To replace that with something that would be uncertain, I think is the fear that that it may not be preferable to the devil that at least we know. Am I done?
Thank you very much.
Thank you very much indeed. I appreciate all this. Thank you.
So we're on in the morning. Do you have any last announcements? We're on for 9 o'clock in the morning. It's a bit of a change. Nothing else from the other organizers? No? No whips to crack or anything? In that case, thank you all very much for, actually, all of the speakers and the questioners as well for a really interesting day, at least from my perspective. Thank you.